Okay, evening everyone. I'm Robert Carnworth, President of UKELA and Chairman for this evening. We had to delay it just a bit because I was told that the tube was having problems. But anyway, we'll get going. We're here to discuss environmental courts at three levels really: domestic, European and international. We've got three very distinguished speakers for each of those. It seemed to me more logical to start with the domestic scene and move to the international scene through Europe. So on that basis we'll start with Richard McCrory, who's sitting on my right, then go to Carol Hatton, who's on my left, and then end with Stephen Hockman on the far right. The speakers, I suspect, are well known to you, and I'm going to introduce them fairly briefly. We're hoping to have sort of about 20 minutes for each speaker, and then a chance for about 20 minutes of discussion before we go and have a drink. We'll start then with Richard McCrory, Professor of Environmental Law at UCL, former member of the Royal Commission of Environmental Pollution and the Environment Agency. I think most recently he's hit the headlines as the author of a report on regulatory justice making sanctions effective, which has resulted in legislation for enabling agencies such as the Environment Agency to use regulatory sanctions rather than the criminal courts. And you may not have picked up the fact that we already have the seeds of an environmental tribunal. I happen to be president of tribunals, so I know this, that there's something called the first tier tribunal, which has been set up to bring together a whole range of tribunals of all sorts and kinds. One chamber is called the General Regulatory Chamber, and there is now being created within it something called the first tier tribunal brackets environment, which will, in due course, provide the appeal route for people affected by decisions under the McCrory regulatory regime. At the moment, all it is a sort of notional jurisdiction with some notional rules, but in due course we hope to have some judges and people, and it'll probably take off from later in the year. So with that introduction, I will hand over to Richard.
Thank you. Keep an eye on the time. Well, as you heard, I'm going to kind of start, I don't know whether it's the banal level or the local level, but I'm going to focus on the possibility of some form of environmental court or tribunal in England and Wales. And I think Sir Robert's already given a little bit of the game away. Just you know. Last month, the World Resources Institute published a major study on the state of play of environmental courts and tribunals around the world, the Pring report. And they identified, as you can see, over 350 forms of various courts and tribunals. I think they took a fairly generous view on what they characterized as constituted such a court. But you can see it's a large number. And I think what's even more impressive or interesting is that over half of these were created in the last 6 years. Now, some of the names will be very familiar to you, and some have been made with South Wales, Brazil, and so on. There's some I hadn't heard about, the Bahamas, the Malawi court. The Vermont Environmental Court is the only strictly environmental court in the USA, and again, always gets left out of studies, and the main judge there, Meredith Wright, is always complaining that everybody forgets about her, but she is there. This map does come out. That's a map with the countries, and of course it will be noticeable that the United Kingdom is blank there. So I think one might just start, before we all get too excited about this, what are the arguments against having an environmental court? And I think there are some quite powerful arguments still there, and that explains some of those blank countries. And they're ones that we've wrestled with and discussed, and I think they'll still be there. First of all, is environmental law, can one really say it is so different from other specialised areas such as health and safety law or transport law and things like that, that it does really warrant some sort of separate jurisdiction in court? You have to make that argument, otherwise you won't get very far. And again, there are always going to be difficult boundary areas. What truly is environmental? And we might have different conceptions of that. And indeed, if those of you are following the potential implementation of Aarhus in this country, in particular the cost things, both the courts and Jackson Review and so on have said, well, whatever the demands of Aarhus, this is not something we should separate just for the environment. It's something we should either apply across the board or not at all, essentially. And so that argument is still there and will affect here. There's also a case for saying that there is a danger that if you put all the environmental cases in some sort of specialised court, they get rather marginalised. They don't get seen to be as in the mainstream. And that could be a bad thing for environmental law. The next argument is, well, actually, aren't we all about environmental integration? What Gert Winter, famous German environmental law, said the fourth stage of environmental law is to inoculate, wonderful word he used, inoculate all areas of law, company law, competition law, with the environment. So actually we're going against the trend by trying to set up a separate environment court. We should be thinking of integrating the environment into all areas. And that indeed is the very reason the centre that I have at UCL is not called the Centre for Environmental Law. It's quite deliberate. It's called the Centre for Law and the Environment, because I personally don't want a narrow conception. You have to make sure, is there sufficient caseload to warrant a new court? And of course, particularly in these times, anything that's going to impose major costs on the public purse will not go down at all well. And finally, there is some evidence that small specialised courts can actually suffer a kind of capture thing, where they have specialists who might be I'm sure Peter wouldn't be, but ex-Environment Agency employees who perhaps always favour the agency. I've just been in the States, and one of the examples of environmental courts listed in Pring are in fact the administrative judges within the EPA who hear appeals. Now, they are in one sense independent, although they're paid for by the EPA. When you talk to industry, they say, well, these are ex-EPA employees who always favour the EPA on whatever it is. That's their natural inclination. They don't see them as an independent court. They've been captured by the EPA. So you have to recognise these are dangers. Now, going back on the UK arguments, I would say that there were two phases, and I characterise them both as a lot of analysis but no action. And I start, and I'm not just trying to suck up to your president, but I think the first formal reference to some form of environmental court or tribunal was in Sir Robert's 1989 report concerned with enforcing planning control, where he argued, and he could see there might be a case for some form of specialist planning, I think very much connected with land use planning and the environment. We then get the famous 1991 UKELA lecture by Lord Justice Wolfe, where called Are the Judiciary Environmentally Myopic, which is always good to have a catchy title. And part of what he was doing actually in that lecture, if you go to it, was to say, well, judges in fact should be quite circumspect in what they do. And again, perhaps I will mention the Heathrow Airport case, but very clear there are things that are appropriate for courts to be doing, and there are things which are inappropriate. The courts are not the best place to determine these issues. And part of his role was to make an argument that in the UK it is quite right that judges don't make policy, don't get too involved in environmental policy, and so on. But he then also tried to make quite a powerful case for saying we should have some form of one-stop shop court. And his argument was you can have a single pollution incident, something what's going on in the States now, and it could give rise to, if there's deaths, a coroner's inquest, civil claims, administrative law, judicial review if there are public bodies involved. Why don't we have this all determined in one court? I have to say, but with due respect to Lord Wolfe, it was a little bit incoherent exactly what this was meant to do. Would it combine everything and so on? But it certainly put it on the map. That was followed by Malcolm Grant's report, who's commissioned by DEFRA to look at environmental courts around the world and to come up with models for a possible environmental court or tribunal in this country. And again, I don't know why am I being so rude to these people, but Malcolm Grant is my provost. But I think that report had all the virtues and defects of a good academic study. I mean, it was completely thorough, it was analytical, had all the right things. but incredibly lengthy. There was no, even the executive summary was very, very long. And so it failed actually to capture the political, is that fair? The politics of the situation. How do you get the message across? Also, he was a bit hamstrung because DEFRA deliberately said, we don't want you to opt for a model, just analyse. So he had 6 different models, ranging from extending the planning inspectorate to what he called the Big Bang, the full-blown environmental court. So that was the kind of first stage. The second stage I call still analysis, but slightly more with the eye on the politics of actually trying to get the message across. The Royal Commission, in its study on basically on land use planning and the environment, the 23rd report, had a very important chapter on how do you increase and enhance public confidence in the system. And one of their arguments was that there was a case for saying we're getting a growing number of laws about the environment which have various forms of statutory appeals against consents, conditions, and whatever. And where are they being heard? And it doesn't seem to be very coherent. Sometimes it's the planning inspectorate, sometimes it's not. Is there a case for some form of tribunal to hear these? And in fact, it added kind of radical element to say, well, we might also think about a third-party right of appeal, because many, with due respect to those who do judicial reviews, I think it's still the case that many judicial reviews are really merits reviews, people who want to argue the merits disguised as law reviews. Well, maybe there's a demand and they should do that. The Royal Commission raised that. As a result of that, I and Michael Woods was commissioned by DEFRA to look specifically at that particular case, and we produced our report. And one of the things we did do was to, it's a horrible thing to do, but analyse about 75 separate agriculture and environmental regulations and say, well, where did the appeals go to? Most of them had appeals, some of them didn't. And the appeals went all over the place. They went some to the planning inspectorate, some to the Secretary of State, some to the High Court, some to the Magistrates' Court, and some had no appeals. And we did argue that this is a muddle, we were losing out on something, and there was a case for a specialised environmental tribunal, which would essentially hear those sorts of appeals. I wasn't convinced then, and with due respect to Carol, I'm still not convinced of a kind of full-blown, integrated, big environmental court somewhere sitting in the High Court, determining judicial reviews and civil and maybe criminal in a kind of that way, the kind of Wolf model. Didn't seem to me that was very coherent, and also had an eye on the politics, so that just didn't seem to me it was going to happen. However, DEFRA also commissioned WWF and the Environmental Law Foundation to look at environmental justice generally. And when it came to models, they thought I was much too cautious about this, and we should actually go. There was a case for some sort of bigger, what Martin Grant called the Big Bang theory, that only if you create something really good, then you'll begin to get really interesting principles and cases, and you'll release a whole lot of things. Anyway, as a result of that, DEFRA, and of course any government, faced with competing views, even from within the environmental law community, just sort of said, okay, let's not do anything. And it wasn't helped, and here I am being rude again, but the minister with the most interest in this, who was terribly nice, Michael Meacher, but he had no political clout within the rest of Whitehall or even with his Secretary of State. So that didn't hear. So there we have an awful lot of analysis. The first chairman of the Royal Commission on Environmental Pollution always argued that when you had major changes in environmental law or policy, you needed two things. You needed good analysis, but you also needed what he called an ignition event, some sort of scandal, you know, and some of us go back to cyanide waste and all of that. If you have just the scandal without the analysis, then you get knee-jerk reaction laws, it's not very thought out. But if you have the analysis without the scandal or the ignition event, then nothing happens, the politics. Now, the problem here, it seems to me, is that there's no real ignition event taking place, and I don't think there will do in this sort of area. There's lots of kind of gripes and things that don't seem to quite work. They don't work, and they could be better. But I do have a theory that although in some ways Ashbury is correct, I think there are other ways of getting major changes, and what I've called the unexpected alignment, where it just happens there are a lot of other changes going on, nothing to do with the environment, instigated by other motives, and it just happens to all align at the right moment, and that's when you seize for it. And I think there are a number of current influences and pressures and changes taking place, which actually now do provide, there's a new opportunity for creating some form of environmental tribunal. First of all, we do have the Aarhus pressures on, particularly on judicial review, but about the costs of going to court, access to justice. You'll know, most of you will know about the Sullivan report, the Jackson review. We've got the European Commission reasoned opinion, and Carol can say much more about that. But that's clearly making people in this country and the officials and the judges having to rethink and ask themselves, are we meeting the aspirations of access to justice in the Aarhus terms? Should we be doing better? Secondly, and you've already heard about this, the reform of the tribunal system that has taken place in the basic framework, and now we should get all the benefits of that. Now again, that was led, nothing to do with the environment taking place, this reform. It was happening for completely other reasons, the Leggett review and so on. But it seems to me, and again I hesitate with the president of the tribunals here, but the key elements are the flexibility to adapt to the needs. In the old days, you basically needed new legislation if you wanted to set up a new tribunal. When I did that report, called for a tribunal, it would have required new legislation. You now don't. The system has got the flexibility to adapt and to create chambers within it and so on. And secondly, both legal and the non-legal specialisms can be brought to bear within the tribunal system, again, as needed, the sorts of disciplines, the sorts of stuff. And lastly, very importantly, there is essentially, well, certainly for anything new, a clean slate on procedures, costs, and so on. So one can really start thinking again, how do we best resolve these things? Thirdly, you've already heard, the new environmental civil sanctions following the review I did in the legislation. And as you all know, and I'm very pleased to say, that the first regulators who had the nerve to go forward for this, or they're going to regret it, I don't know, was the Environment Agency and Natural England. I think basically all the other regulators, and it's supposed to apply to everybody, they can take it, are all sitting back and seeing, you know, let first movers. So I pay tribute to Peter Kellett and the other first movers in the agency who've now got to work this out. But the important thing, and I was very clear in the review, and I'm glad the government picked this up, that any appeals against penalties or notices, compliance notices, should not go to the ordinary courts, either the criminal courts or the High Court, or indeed the planning inspector, but should go to a new chamber of the tribunal sitting within the first-tier tribunal system. That was the appropriate thing to do, to develop principle, to consistency, and to have the right kind of legitimacy for doing this, because it will be, you know, complicated. So that clearly, given that for the next year or two, the first sorts of appeals, if there are any, will be in the environment, clearly we see the possibility, well, that's where the work's going to be. And lastly, I go back to what I analysed in my first report, the appeals routes under existing legislation. Now, in 2003, I think it was 57 sets of environmental laws that we examined, and as I said, found a complete muddle. Although it was true that the planning inspectorate were beginning to take on more appeals, and so maybe that's where it was shifting. Now, I've recently done, partly in preparation of this, I thought, well, I better have a re-look, because there's been a lot more environmental law. Where is it all going now? Is it now a more coherent system that's taking place? And I have to say, I think that that's interesting, that the appeals routes are still as incoherent as before. And this isn't comprehensive at all. And you'll see here, I've got two sets of sites. Some are still going to the magistrates' court. We have the planning inspectorate. And again, it's quite complicated, because sometimes the planning inspectorate, what's happened is that they're formally delegated powers from the Secretary of State. He's got the power to delegate the decision to the planning inspectorate. Sometimes they're still reporting to him. But what's got more complicated now is that we have different government departments. Although it says Secretary of State, and then you think, oh, that's nice. And I have to explain wherever Manuel is from Spain. When it says Secretary of State, we have kind of one Secretary of State, but hundreds of departments. So you have to break this down. So we now have business innovation skills for some of them, and some going back to the ministry. I take more here, waste back business skills. Now we have energy and climate change coming in, and back to the planet. And then at last, the first tier tribunal at the end. Now, Diversity, of course, can be a strength, and I'm not denying that. But I think what's more worrying to me is that, it seems to me this picture is still a lost opportunity in developing some sort of more coherent principles and so on. When you look, and I want to do some more work on this to get this going, but some examples of appeals held by the Secretary of State in non-deferent departments. And I'm sure people here who've been involved will tell me they find, yes, I've one more. I think they're just making it up as they go along. And to take 3 separate cases, one of them was heard by a retired civil servant. Another one was held by a QC and a technical assessors. And the third one, which was most recently last year, was held by the Deputy Legal Secretary in the department, who held an oral but closed hearing. Yes, I mean, that's what and again, I get back to the thing. They're all honourable people, these, and I'm sure they're held within their own way. They're perfectly right. But I'm just saying we could do much better. And lastly, I turn, and I know this is dear to Peter Kellett's heart, but the recent appeal decision on deemed water, the discharge consents, which has been in the press again. And again, I don't want to denigrate the particular planning inspector who was dealing with this, and I'm sure he dealt with it best he could. But this is a case, a lot of it turned on a very complex assessment of EC law and whether we're complying with it, and whether it's right that a planning inspectorate with no legal qualifications should be determining that. I don't know. I leave it to you. So my model, and this is my last slide, is that we should think about an environmental tribunal for England and Wales, and there are reforms taking place in other areas of environmental law, judicial reviews, the criminal law, and so on. So I would still advocate that we shouldn't go for some full-blown new division of the High Court dealing with the big civil litigation or judicial reviews. I think we have to improve all that, and we're all working on that. But we should focus within the Environmental Tribunal both the appeals against the civil sanctions and increasingly statutory appeals under environmental regulations. And I think it's perfectly possible, and I take the point that there are planning inspectors who are highly qualified who've been dealing with this. As I understand it, under the new flexible arrangement would be nothing to stop the appointment of individual planning inspectorates within the tribunal and so on. So one could do that. And I think there is a good case to be made for this. And lastly, it is possible, as one knows, to transfer classes of judicial review or individual ones now to the upper tribunal. As yet, I'm not sure if there is a case for doing this wholeheartedly in the environmental field because of the numbers, but if as a result of Aarhus and having to comply with Aarhus, we actually release a very large number of people who want to bring cases for judicial review, and they've got genuine cases, well, I think we're going to have to rethink how we do it. And I suspect the High Court is not the best place to hear all those cases, and this is where the tribunal system might provide another mechanism. So there are lots of opportunities afoot at local and national level. Thank you.
Well, thank you very much, Richard, and particularly that it all seems to hang on the new tribunal system. So we've got a big agenda ahead of us. Now we'll move then to Europe, and Carol Hatton, who is in-house solicitor for WWF UK, with a long background in environmental sciences, and has been working in a number of organisations on that, and is as expert as anyone around on those issues. Carol.
Okay, thank you.
It's very interesting stuff, actually.
We'll sort of that. We'll get there.
Yeah,
we can talk to Ken Clark.
Right, thank you very much indeed. I hope my voice doesn't give out. I'm sorry, after 40-something years, I seem to have developed some sort of weird hay fever. So my voice is not very good, but anyway, I have a good mic, so I hope I'll be okay. Now, what I'm going to look at this evening is how good the European Court is as a forum for environmental cases. So I'm not going to be talking about any of the UK issues, costs issues that some of you might normally associate me with, and I'm sure some of you are probably quite relieved about that. If we're thinking about the European Court, what are some of the indicators that we might look at to judge whether we think it's a good forum? And I've listed out some of the more obvious ones here. legal standing, transparency, expertise, effective remedies and injunctive relief, and costs and legal aid. And I'm going to talk briefly about some of those, and I'm going to use 3 cases that WWF has been involved in to talk about some of those. If we can start off with standing, because I think standing is, I mean, it's a critical issue. If you can't even get in through the door, you can't even get off the starting blocks for access to environmental justice. And if any of you have used the European Court, you will know that it's actually a very criticised issue at the European Court level. I'm going to discuss the situation pre the Lisbon Treaty, but I am going to come back briefly to the Lisbon Treaty and how it might change things at the end. And what I'm going to do is talk about Article 230, which is the situation we've all been working with up until now, which essentially has 2 limbs under it. The first limb is where you individually are the recipient of a decision of a community institution. So, for example, you might have asked for a particular piece of legislation and that may have been refused. And in that situation, you have no problem. You don't have to establish standing. You can go straight to the court. The second limb, however, is much more tricky. That's where we're talking about decisions which are issued much more generally in the form of something like an EC regulation or a directive. And in that situation, you have to show that you are directly and individually concerned by that decision. Now, direct decision has been something which the court hasn't massively concentrated on, but individual concern really has been something which it's focused attention on a lot. And the key test for that was set out in a case which is now nearly 50 years old, I guess, if that's 1962. It was a case concerning the importation of clementines. It's well known as the Ploughman case. And that case established that it says, individuals other than those to whom a decision is addressed may only claim to be individually concerned if that decision affects them by reason of certain attributes which are peculiar to them, or by reason of circumstances in which they are differentiated from all other persons, and by virtue of those factors distinguishes them individually, just as in the case of the person addressed. And I think the key test, really, or the key wording there is those last 12 words. You have to be able to demonstrate to the court that your particular circumstances are so strong that you are individually addressed in exactly the same way as somebody who was brought under the first limb of Article 230. Now, that's proved to be a very difficult test, a very difficult threshold to meet. And I'm not going to go into these cases, but these are some of the very well-known cases in which individuals and NGOs have tried to establish standing before the European Court and have failed because they've not been able to show that they are individually concerned by a decision. And that includes, I would say, individuals who actually, who have used the fact that their livelihoods are going to be destroyed as standing, and they still haven't been able to get in through the door. I'd like to just briefly mention one case, which is now concluded, that WWF took precisely on this point. We have a major work stream on fisheries, we have done for many years, and we've been very concerned about the decline in cod, particularly in the North Sea and the Atlantic Sea. It has been declining. Some in the 1970s, the yields that were being caught were something like 1.4 million tonnes a year. We're now down at about just over 200,000 tonnes a year, and that's because the stocks aren't being allowed to regenerate. Now, there's a body called the International Council for the Exploration of the Seas, ICES, and for the last 7 years, that body has said that there should be a zero catch of cod to allow juvenile numbers of fish to replenish itself and for the population to regrow. WWF sits on a body called the North Sea RAC, the North Sea Advisory Committee, and that's a body that's set up under an EC regulation with an express statutory role in feeding into the decision-making process on the quotas. So it's there really to provide advice to the Commission, to the Council of Ministers and to the individual fisheries ministers at the member state level. The quotas are set annually, every December, and in 2007, in the period October, November and December of 2006, we took a number of steps to make sure that the Council of Ministers, all of the individuals fisheries ministers and the Commission were well aware that the only lawful approach they should take should be to set a zero quota for cod. Despite that, unfortunately, they only reduced the quota from the previous year by about 14%. So on the basis of that, we sought to challenge that decision in the, as it was called, the CFI, in March 2007. Now, the Council challenged our individual concern and the Commission intervened in support of the Council. And we were required to show two things. They didn't really spend much time going into direct concern, but they did say two things. You have to show that your legal interests are individually affected by that decision, by the setting of the quotas. And that's quite difficult for an environmental group to do. If you are a fisherman and you can show that your financial considerations are going to be affected, you might be able to show that your legal interests were affected. But as an environmental NGO with environmental objectives, it was quite a hard argument for us to make. Secondly, they said that we had to show that we were individually concerned, and we had to show that our position on the North Sea RAC was such that we were given sufficient procedural guarantees that we were differentiated from anybody else who might have been interested in how the quotas were being set. Now, unfortunately, we weren't able to persuade either the CFI or the ECJ that we should have had standing before the court, which of course was massively disappointing. And the ECJ said three, I think, very disappointing things. Firstly, they said if there are any procedural rights existing as a result of you sitting on the RAC, they exist for the RAC as a whole. They don't exist for its individual members. And that wasn't much help to us because we were a minority interest on the RAC. 2/3 of that are made up of fishermen. So we never would have been able to persuade the RAC to take a case to court. Secondly, the court relied on a new case called Schmolt, which had not been raised by either the Council or the Commission, to create a new and even more restrictive test for standing. And perhaps most worryingly, the court said even if there is a right, and we're not saying there is, but if there is a right, that only exists for you to challenge procedural unlawfulness and not substantive unlawfulness. And we had particularly argued that under the Aarhus Convention, we said fisheries, the setting of quotas was an activity covered by Article 6. And under that article, you are required to provide a substantive review as a result of Article 9 of the Aarhus Convention. We did raise both the Aarhus Convention and the Aarhus Regulation in our submissions. Unfortunately, the Aarhus Regulation had not quite come into force. It was due to come in 3 months later. That provides an internal review procedure which enables NGOs to submit a complaint internally. We had all hoped that that might actually then mean that we wouldn't have to satisfy the test for individual concern, and we've been able to get into court. I'm not going to go into the limitations of the Aarhus Regulation. There are quite a few. All I would say is that it isn't a panacea, but we did hope that that would be one particular way in which it would help everybody. But unfortunately, the CFI poured cold water on that. They said that any entitlements which the applicant may derive from the Aarhus Convention or the Aarhus Regulation are granted to it in its capacity as a member of the public. Such entitlements cannot, therefore, be such as to differentiate the applicant from all other persons within the meaning of the settled case law. And the ECJ was silent on that point, so we can only assume that that still stands. So, unfortunately, it looks as though the Aarhus Regulation isn't actually going to make any difference in terms of standing before the European Court. Will the Lisbon Treaty make any difference? Well, it might. Under the new Article 263, which replaces 230, if you're seeking to challenge a regulation, which of course we were, you now don't have to satisfy the test of individual concern, which has always been the problem. However, I think the real litmus test is whether the court really still actually want to let people in. Because if they wanted to, they could just then adopt a very strict interpretation of direct concern. And remember, they've never really looked at this before, so there's not really very much case law to help us on where they will go with that. Even if that is helpful, though, there is still a requirement to show sufficient interest, which is difficult for NGOs, and there's still no substantive review available for some of those activities for which there should be a review under the Aarhus Convention and the Aarhus Regulation. Just a quick slide there to show that we have raised this within the Aarhus Convention Compliance Committee. Both Stephen and I were over in Geneva in September. We gave written and oral submissions to the Aarhus Convention Compliance Committee. We very much hope that they're going to address this in their findings for their meeting in June, so we might have hopefully some recommendations about the European Court coming out of that June meeting. And also I think WWF has produced a report on this which we published last year. It was written by the IEEP. If anybody's very interested in the issue of standing and would like to read more. I'd like to move away from standing and talk about transparency, which is another issue that WWF is very concerned about. And I'm going to talk about a case that we took in 2004 on trade. We took that as WWF UK on behalf of our European Policy Office. And we sought a number of documents that were held by a very small and little-known committee called the Article 133 Committee. It's a committee appointed by the Council to assist the Commission on trade policy. And really what it is a sounding board between the Commission and the Member States. It's very small and it's very secretive, but it's very influential. It rarely publishes minutes or even agendas or very many papers. Anyway, in 2004, we applied to that committee for a number of documents. Firstly, a paper entitled WTO Sustainability and Trade After Cancun, plus the preparatory papers and the agenda and the minutes of the meeting it was going to be discussed at. We did raise the Aarhus Convention and the Aarhus Regulation, which was in draft at the time. Now, the Council refused that request on two grounds. They said that disclosure would seriously undermine the EU's commercial interests as well as its economic relations with third countries. And we applied to the CFI in late 2004 to annul that decision. Now, the oral hearing was held in November 2006, and it was one of those fabulous hearings where our advocate really didn't have to do very much. We had 5 judges sitting at the front who were really engaged, giving the advocate for the European Council really quite a hard time about the definition of information, what type of information should be disclosed. Is it just information held in the form of a formal document? Should it cover minutes on somebody's computer? Should it cover their handwritten notes if they're attending the meetings as civil servant? Really very interesting debate in which the judges seem to take quite an expansive view. Just goes to show how wrong you can be. They basically said that disclosure and partial disclosure was not warranted. We pretty much knew that was going to be the case, to be honest. What we were hoping for was some sort of feeling about what sort of information could be disclosed, and they took quite a narrow interpretation of that. They said basically the concept of document can be distinguished from that of information, and the community institutions are only obliged to disclose information held in the form of a formal document, as opposed to anything which might be held in written, visual, oral, or electronic, or any other material form, which is how information is defined in both the Aarhus Convention and the Aarhus Regulation. So that was rather a disappointing judgment. Now, I'm not going to talk about these because it's another transparency case, but I'm going to move on to my third case, in which I'd like to talk about, it's a case in which we intervened in the European Court, and it's a case really just, I think, as just one example of how the European Court takes a view of interpreting European concepts. Now, this is a case which was taken by First Corporate Shipping Limited against the government, against the DETR, and it concerned the setting of the boundary of the Severn Estuary Special Area of Conservation. Now, this was a case in which the judge in the High Court, straight away seeing that the case concerned issues of European interpretation, it was an interpretation of 2 provisions of the Habitats Directive, and sent it off for an interpretive ruling. We were very interested in this, mainly because we could see that the site, the Severn Estuary site itself, was very important. It has a number of important wildlife habitats, things like subtidal reefs, Atlantic salt meadows, mudflats, estuaries, also a number of species like the Twait and Alice shad, and the river and sea lamprey as well. So we decided to try and intervene. In this case, First Corporate Shipping were arguing that the Secretary of State was obliged to take account of social, economic and cultural requirements when they were selecting sites to send off to the European Commission. The Secretary of State was arguing precisely the opposite thing. They were basically saying, in accordance with Lappel Bank, that they couldn't take economic, social and cultural requirements into account when they were selecting sites to send off to the Commission and when they were also setting the boundaries of those sites. Now, as I say, we were very keen to intervene in that case. We'd had a judgment on precisely that point in the Outer Quarter session in Scotland, a very stinging judgment in which we'd had over £200,000 worth of costs awarded against us. So we were very keen to get involved in this case and establish a much better principle at the European Court level. We were very lucky in that the European Court said, OK, we have no problem with you intervening, it's up to the domestic court. The domestic court said, OK, we're fine with it as long as both of the parties are. The European government said that's OK, we were actually intervening in support of them, so I guess that may have helped. And First Corporate Shipping were actually OK about that as well. And we were able to then go off to Luxembourg, and we were treated like any other party. We had our 15 minutes to make our oral submissions. We were able to comment on all of the written submissions as well. So that was a very good way of strategically making our views known at that European Court level. And the judgment that came out, in fact, was very helpful. And it basically confirmed what we all thought was right as a result of Lappel Bank, is that the Commission, when it's actually selecting and identifying sites, has to have an exhaustive list of all of those sites from their member states to enable it to do that. and that also the member states cannot take account of social, economic and cultural requirements when they're selecting those sites and setting their boundaries. So, we've had a look at standing, transparency and expertise. I'm only going to talk very briefly about the other two. I have no direct experience of remedies or injunctive relief. I'm afraid I've had to take this off the court's website. In terms of remedies, if the action is admissible and well-founded, the court can declare an act to be void, and I think with regulations they have the discretion, as you would expect, that some elements of it can stand and some elements can be declared void. On injunctive relief, there's no automatic suspensive effect as a result of lodging an application with the court. The court can order suspension, and that's done by the president of the court, but from what I can gather, it's done very, very rarely. And certainly in the sort of 15, 20 years I've been aware of, working around cases in the European Court, I've never heard of an injunction for environmental cases. In terms of costs, sadly we do have a lot more experience of that, having lost quite a few cases there. But it's basically good news. I mean, it's essentially free. There are no court fees to pay. You have to be represented by a lawyer, but there is legal aid available. Theoretically, that does cover NGOs, although I've never actually seen that happen. But the only recoverable costs are the expenses necessarily incurred by the parties for the purpose of the proceedings. So basically the travel and subsistence expenses and the remuneration of agents, advisors and lawyers. So when you're taking a case against the community institutions, they tend to use in-house lawyers. So the only charges you get is literally their train fare to get from Brussels down to Luxembourg and a night in the Marriott Hotel. So you're really paying, if you lose, 200 to 300 euros, and that's it. Whereas if you win, and you've used external lawyers, as we did with one of the cases we did on Mullock Moor that I didn't talk about, you can actually get a substantial amount of your costs back. And in effect, I guess that's the closest you'll get to sort of perhaps one-way cost shifting, but through the back door. The costs are only awarded if they're applied for by the successful party. They're always applied for. I have been chased up for 60 euros many a time. But the point is that those costs are not prohibitively expensive within the meaning of Article 9.4 of the Aarhus Convention. Putting all that together, what do we think of the European Court? Well, I can't claim credit for this table. This was a table that was produced by the European Commission themselves. They asked a consultancy called the Milia Limited Consultancy to grade all of the member states on access to environmental justice. But what they didn't do, interestingly, is actually look at the European Court. So they assessed everybody else, but they didn't actually look at their own court. So what we did in a report that we published last year, the report I referred to earlier on, is we added the European Community's line at the bottom. So, in fact, what I should say as well, that we use the same criteria as the Milia Limited to actually grade the European Court. So I'm afraid they get rather a bad grade for legal standing. They get a theoretically available, but in practice not terribly well used, grade for effective remedies and injunctive relief. Costs, they get a good grade. Length, they get rather a poor grade. I think on average it takes 7 years for a complaint to go from being lodged by an individual if it's infraction proceedings by the Commission. And certainly my experience is that it's between 3 to 5 years for a case to go through the European Court. And the overall assessment is essentially negative. They're in the bottom 6 along with Austria, Germany, Malta, the UK, and I think it's the last one. Hungary. And I think, that was basically on the grounds that, if the standing position is so bad, and this is similar to Germany, where it's the same situation. If the standing position is so bad, if you can't get through the door, there simply can't be any access to environmental justice, no matter how good your rules on costs are. So that was why they ended up with a very negative result. And finally, just to be a little bit more discerning about that, I would break it down into the 3 different categories. If you're seeking to challenge a decision which has been addressed to you personally, you won't need to address standing. That will be relatively quick because you won't have to have the standing arguments before you try to get to the substance of the case, and you'll probably be at pretty low costs risk. So that's pretty good. If you're seeking to challenge the decision of community bodies more generally, so your directives, your regulations, unfortunately standing will be almost impossible to achieve at the moment, so the other factors are pretty irrelevant. All we can say is let's hope that there is a positive result as a result of both the Lisbon Treaty and the Aarhus Regulation, and perhaps the Aarhus Compliance Committee might make a difference in that respect. And finally, intervening as a third party, that's very variable. We had a good experience, but I would just say that depends on the rules in the domestic court. We recently just tried to intervene in a case in Greece in support of WWF Greece. And in Greece, you can't intervene in support of the applicant. You can only intervene in support of the government, which seems incredibly undemocratic. So we weren't able to do it. So, you know, I think that's something that needs to be, it's very variable. But again, if you can do it relatively quick, you don't have the standing issue. And I think interpretive rulings tend to be moved through the courts quicker anyway. It can be strategically very useful, and you will have cost certainty. So somewhat of a mixed bag, depending on what you're seeking to do. Okay.
Well, thank you very much, Carol. That was a fascinating view from someone who's actually experienced the European Court of Justice in a very direct way. Now we move then to the more international sphere with Stephen Hockman, QC, who is a distinguished, very experienced silk and a former chairman of the bar and has been involved in planning environmental matters for many years, but most recently he's become the director of the Coalition for an International Court of the Environment, and that's what he's going to talk about now.
Good evening, everybody. I must admit that I approach my task this evening with a certain amount of foreboding. And that is not just because the only thing that stands between you and what I assume, I may be wrong, will be your first drink of the day is the relatively brief remarks that I'm now about to make. Not just because I'm doing so in the presence of some very distinguished environmental lawyers, but because in the words of Elizabeth Wilmshurst, that very distinguished former civil servant who gave evidence to the recent Chilcot inquiry about Iraq, speaking about esteemed former Lord Chancellor Jack Straw, she said of him, and the same could really be said of me, he's not an international lawyer, and that was the end of Jack Straw's credibility before that particular tribunal. Well, although as Lord Justice Carnwath kindly said, I have dabbled in environmental law for quite a long time, and it has been, environmental and regulatory law have been the focus of my practice. I can't say that I'm particularly well known as an international lawyer, but I have become very interested in this subject. My chambers hosted a seminar on it a couple of years ago, and somehow the idea has grown and has attracted a lot of support, not just here but around the world. And so what I want to try to do in the next few minutes is to explain to you briefly the case for an international court for the environment, or ICE. On the table over there, I think, possibly underneath that raincoat, which somebody has kindly put on top of them, but there is a pile of papers. I haven't got any slides, but there is a paper which you'll be able to take away with you if you want to, and read about it in more detail and see some of the references. For present purposes, therefore, let me just confine myself to making a relatively few brief points. Firstly, I want to say something about the role of the law in relation to a social issue such as the environment. Richard McCrory made some interesting comments about this early on in his remarks, but I want to put it perhaps in a slightly different context. And I just want to offer you two quotations first from lawyers who you may think, on any view, are really quite distinguished. The first is from Sir Robert Jennings, who was a professor of international law at Cambridge and then became a member of and ultimately president of the International Court of Justice. This is a quotation that you will find, and this is where I got it from, in the foreword to the first edition of Philippe Sand's book on the principles of international environmental law. And Robbie Jennings said this: "It is a trite observation that environmental problems, although they closely affect municipal laws, are essentially international, and that the main structure of control can therefore be no other than that of international law. Now, there is a fairly unequivocal statement by a very distinguished academic and judge of the relevance of international law in the solution of environmental problems. And I just think it's worth linking that to something that was said. It's a rather more general quote, but it's a quote from Lord Bingham's recent book, which everybody knows about, and some people, I suspect, have read. His book on the rule of law. He laments the fact, he's got a whole section on the international rule of law. He laments the fact that the compulsory jurisdiction of the International Court of Justice is accepted by only a minority of member states of the UN, and by only one of the 5 permanent members of the Security Council, namely the United Kingdom. And he says this: if the daunting challenges now facing the world are to be overcome, it must be, and this is where it's very similar to what Robbie Jennings said all those years ago, it must be in important part through the medium of rules internationally agreed, internationally implemented, and, if necessary, internationally enforced. That is what the rule of law requires in the international order. So my starting point is that if we are confronting, as it surely must be absolutely common ground we are, huge international problems in relation to the environment, climate change being perhaps just the most important and the most serious, but a whole group of problems, biodiversity and so on, a whole group of problems relating to the environment, and without seeking necessarily to give a definition of the exact boundaries of the subject, but if on any view we are facing these enormous problems, then we need to recognize, and the world needs to recognize, just how important the law is in the solution of these problems. Just reflect in passing that many, many social problems that we have succeeded in addressing over the years have been solved not just by political or social change, but by developments in the law, and indeed by developments in legal cases and by judicial pronouncements. An example that I have given more than once, and which I think is helpful, is the way in which significant social change was brought about in relation to people's smoking habits. The whole attitude of society towards tobacco and the health effects, you might say in the broadest sense the environmental effects of smoking, has been revolutionized in our lifetimes by a combination of a change of attitudes, and these things are interrelated, and there's no point in debating which causes which, by a combination of a change of attitude on the one hand and by legal changes, both legislative and, I would say, judicial as well. And the litigation that was brought, not all of it successfully, but some of it successfully, the pressure of litigation has undoubtedly contributed to very beneficial change in that particular area. It was a very major problem on a worldwide scale, and most people would probably agree that the problem has been substantially reduced, and that might give us some reassurance as to our capacity to address the environmental problems that face us now, but only if we acknowledge the importance of the law and of judicial decision making as well as legislation in attempting a solution to those problems. Well, now let me move from that, staying at the international level, and discuss the various ways in which the law might make a contribution. Manifestly, enacted law, legislation at an international level, we're talking really about treaties and other international conventions, will have to play a very, very important part. And we see how the world is struggling to arrive at legislative solutions to some of these problems. And the recent meeting at Copenhagen and the attempt there to arrive at some new law, to arrive at a convention on methods of dealing with climate change, has not so far been markedly successful. And it seems to me that one of the key lessons to be derived from those attempts to introduce legislative change in that context, in the context of a meeting like the one that took place at Copenhagen, is that what we need to be looking at is not just new legislation, but we need to be considering the possibility of institutional reform. We need to recognize that the one major international judicial institution which we have, the International Court of Justice itself, has, of course, a hugely distinguished reputation, but it has its limitations. It's available only to decide disputes between states, only those states which consent to its jurisdiction, and it has relatively rarely had to deal with environmental cases. Very few environmental cases have been brought before it. There was an environmental chamber. They set up an environmental chamber, I think, about 20 years ago. It was disbanded recently because nobody had ever brought a case before the environmental chamber. And the International Court of Justice neither needs to expand its jurisdiction or to expand its remit, nor, I would suggest, is it likely to do so. This isn't in the least a criticism, but it is simply an acknowledgement of the fact that its jurisdiction is limited, and that if we are to see environmental cases being pursued at an international level, we're going to have to consider institutional reform. Now, very, very interestingly, in my view, people are starting to talk about the reform, institutional reform, in an environmental context at this very moment, not just in terms of judicial institutions, but in terms of a body which many people refer to as a World Environment Organization. That's a concept which is increasingly coming under discussion. The United Nations Environment Programme has been talking about it, and the UN itself has decided that in 2012, at Rio, 20 years after the famous meeting at Rio in 1992, there will be another convention, Rio Plus 20, at which, among other things, I'm quite confident from what little research I've been able to do, the possibility of setting up a World Environment Organization will undoubtedly come under discussion. And it seems to me that perhaps it is through that route that the possibility of establishing an international court for the environment is most likely to arise. And I think that one of the factors which is leading to a growing feeling that this is necessary is that we increasingly see examples of cases in which this is quite likely to be a necessity. And let me give one example. Richard mentioned earlier that in order to bring about radical change, you need not just to be able to theorize about a proposal, but you need an event which in some way ignites the support of the public. Now, we all know about the recent oil disaster in the Gulf of Mexico, and I suppose it is quite likely that that is is an issue which is capable of being resolved under our existing legal institutions. I mean, presumably action can be brought by the American government or by people within the United States, within Louisiana, against BP in the courts of the United Kingdom, in the courts of the United States, or somewhere in the world. You could say that in relation to that particular incident, you don't need a new institution. But suppose, and it seems to me this, though this is an imaginary case, it is far from being fanciful. Suppose that a Chinese oil tanker sustained some form of accident very close to the coast of Bangladesh. Bangladesh is a country which is, as you know, more vulnerable to environmental problems than most other places in the world, more vulnerable in particular to the effects of climate change, heavily dependent on, its fate depends heavily on the fact that the river Ganges flows out into the ocean and rises and falls, and parts of Bangladesh are underwater at some times of the year and not at others. This is a country which is as sensitive to environmental problems and environmental change as almost anywhere in the world. Now, suppose an environmental catastrophe of the kind which we can see in the Atlantic were to occur there. It wouldn't be an oil well, but it could be a tanker or something of that kind. And the waters of Bangladesh suddenly became polluted. How is that problem going to be attacked in terms of litigation and at an international judicial level? I venture to say that at the moment it's very hard to see how that injustice could be met without a new institution. I was discussing this sort of problem, as it happens, at the Bangladesh High Commission in London recently, and it was obvious that they were very, very concerned about it, and particularly interested, as it happens, and I've found this in the discussions that I've had, particularly interested in the concept that you might cite an institution of this sort within the developing world, perhaps precisely at a place like Dhaka, the capital of Bangladesh. You know, nobody has thought about citing an international institution in the very place where it's most needed and in the part of the world whose support we so badly need for these international discussions that we're having. Until we reverse our normal assumptions and think about according status and self-esteem to some of these countries, it seems to be that the problems that we experienced in Copenhagen are going to continue. So, to my mind, although it may sound idealistic, this notion of institutional change and the notion of establishing a new international institution such as the International Court for the Environment is entirely realistic, and within the next 5 years I think we're going to see developments on this front. Now let me briefly deal with two further things. Let me say in a few sentences the concept behind this idea, and let me deal very briefly with one or two of the objections to the idea which we've been discussing. First of all, so far as the concept is concerned, in the medium term, I think we certainly do envisage that there will be an international treaty of some kind, perhaps something that might be discussed at Rio in 2012. That may be too soon, but an international treaty which considers the setting up of an institution such as this. But even before that, we see the possibility of a tribunal being set up, if you like, on a voluntary basis. We see the possibility of gathering together a group of distinguished judges or former judges, a body which would be available to perform an arbitral function. For instance, under the Framework Convention on Climate Change and under the Kyoto Protocol, under the arbitral provisions in those agreements, where there is provision for people to refer their disputes to arbitration by an identified body. I was rash enough in conversation the other day with Lord Justice Conworth to invite him to consider accepting the post of the president of this body. I suppose it was a rather clumsy attempt to curry favour with him when I knew he was going to be chairing this meeting, and quite rightly he remained fairly reserved about the proposition. I'm sure he wouldn't have considered it unless I had told him about the proposed salary, among other things. But as I say, I do think that
it's in Bangladesh, is it?
I do think that the prospect of setting up a group of this kind, you would need some funding, but not an unattainable level of funding to set up a group of this kind, which would be available to arbitrate in disputes of this sort, and above all, which would be open not merely to states but to non-state actors as well, to NGOs and to private individuals. And if it was linked to a World Environment Organization, at a discussion we were having earlier this week, a highly intelligent lecturer in law at the LSE called Veerle Havertz suggested that the World Environment Organization could be the filter, could be the body to which complaints were initially submitted, which could be responsible for investigating those complaints and then passing them on to the International Court for the Environment if they merited inquiry. Well, time doesn't permit me, so I see from this piece of paper, to go into the concept in greater detail now, although I suppose we'll have a few minutes for questions. Let me very, very briefly just mention that, and again this is something that Richard McCrory himself addressed, we have thought about some of the objections to this proposal that people might advance and try to consider what the answers to them might be. And let me just deal with one point and let me end on this. And I think this is a really interesting point, and it's another quotation, and it comes from a textbook. And here I'm going to reveal something to you and slightly contradict what I said right at the beginning, because actually I did spend a year studying international law. When I was at Cambridge, there was an international law component in the tripos. You did it in your first year when you knew nothing at all about law of any kind. It was a strange point at which to have to delve into international law. But there's a very good and very clear textbook on the subject by a man called J.G. Stark. I don't know if anybody else ever had to use that book. And the issue that he was addressing is an issue that often arises in this sort of discussion, which is what is the point of setting up an international court if there is no international police force? How are its decisions going to be enforced? And let me literally conclude on this. Let me just give you a few lines from J.G. Stark, An Introduction to International Law. My edition is dated 1966, and I wrote my name in it at the time, which I think is interesting in addressing this problem of the enforceability of the decisions of a body of this kind. He says this: assuming, however, that it be a fact that international law suffers from the complete absence of organized external force, would such circumstance necessarily derogate from its legal character? In this connection, he says, there is a helpful comparison to be made between international law and the canon law, the law of the Catholic Church. The comparison is the more striking in the early history of the law of nations, when the binding force of both systems was founded to some extent on the concept of the law of nature. The canon law is, like international law, unsupported by organized external force, although there are certain punishments for breach of its rules, for example, excommunication and the refusal of sacraments. But generally, the canon law is obeyed, and this is the serious point, because as a practical matter, the Catholic society is agreeable to abide by its rules. This indicates that international law is not exceptional in its lack of organised external force. The problem of the binding force of international law ultimately resolves itself into a problem no different from that of the obligatory character of law in general. Well, I hope I've at least stimulated a little thought and given people the opportunity to think about these problems as they enjoy their first and I hope not last drink of the evening. Thank you.
Thank you very much. There is a very interesting paper, it's that one, yes, which I do urge you to read, because it's simply not been possible in the time to go into it in any detail, but there are some very interesting ideas in that paper. Now, we've got about, a quarter of an hour possibly for any questions, discussions, points on any of these subjects, which range across quite a wide thing. Yes?
Ole Pelles from Newcastle. I have a question for Carol. I wonder, I think we'll just have to wait and see how Article 263 develops and the additions to that. But in terms of the perspective of the EU acceding to the ECHR, I wonder if you think there's any prospects in that in terms of arguing ECHR Article 6 complaint before the ECHR, saying that 263 does not conform to Article 6, although I suppose the former Yugoslavian airplane cases indicates that the ECHR is not interested in going into this. But I wonder if you have any thoughts on that.
Yeah, I think that's now possible, isn't it, under the Lisbon Treaty? But doesn't it still have to? There's some sort of procedural hook, some sort of procedural matter that has to take place before they can actually take it forward.
Well, they have not exceeded. I'm just wondering.
Yeah, I think it's now possible.
Future,
yeah. I don't know actually. I mean, my feeling is we looked into this because when the Aarhus Convention Compliance Committee were looking at the EC, they actually wrote to us all and said, "Well, do you think the Lisbon Treaty?" And this was one of the matters that they particularly raised. And I think we were saying, well, it may do, but I mean, it's certainly, if it's going to happen, it's going to be a long way away. And again, it very much depends. I think it just depends. Really comes down to whether the court has got the will to do it, because so many of these things. I mean, the Plowman test is not something which was established actually by the treaty. It's an interpretation the court has chosen to take. So I think unless the court is actually willing to move its position, in a way they can sort of work around any of the obstacles that are put in their way. So I think it's really down to the will of them actually adopting a completely fresh approach.
Yes.
I just want to focus on I suppose, on the question or the issue that Richard and Corey raised against environmental courts, which was that they're not so different from other specialised areas of law that not raised. Listening to what Carol was from the two big issues seem to be standing and costs. Which stand in the way, or things that differentiate, in a sense, environmental courts from other areas. And also, I just wanted to add something else to get into there as well, in terms of, I'm not sure whether powers of tribunals have this, but courts have powers to make declarations as to what the law is. And I suppose there's a principle, it seems, of conflict in that litigation, which may not necessarily be right until we allow them to maybe a frame more of a positive sort of, rather than conflict, to make the change, you move to sort of a common framework through the understanding of the law to make action to make the change, rather than conflict. And whether there's any views as to whether a court which looks at these three areas, irrespective of standing, look at standing, taxpayer costs, and how to make declarations irrespective of standing, whether those three things could distinguish a court from other areas.
Do I have to press this? No. Nothing. Well, you're quite right. In a sense, I raise those arguments because those are arguments that have to be addressed. And I think actually when I was doing this study for the tribunal, and Sir Robert was on an advisory committee, and they did at one point said, well, why the environment, not where else? And, I'm a reasonably good advocate. And I did make a case here of, I think, 6 features which I identify, which distinguished the environment from these other areas. I mean, and it was actually the combination of them all that made it, I said this makes it rather distinct. But it's still a difficult argument. And when we mentioned about the civil sanctions, and I'd already done work saying there was a case in the environment to have civil sanctions, look at that. But again, it's quite difficult. And actually one of the joys of doing the Cabinet Office report, which was about regulation generally, across the field, I didn't have to worry about that because I could actually make a case in all areas of regulation. There was a case for not getting quite so hooked on the criminal law. So that actually released all those arguments. So I think I would still argue for a full-blown, what I call the full-blown environmental court, a distinctive civil court, a distinctive administrative court, or a distinctive criminal court. I'm not yet convinced that the issues are so distinct. I think there are lots of cases, Aarhus we have to do something about, and that is to do with law related to the environment, how we do it. We've got to do something, that's driving that. But I think one of the, just to get back to your declaratory point, and I'm not talking about a kind of judicial review declaration, but I think to me one of the tricks we're missing by having these rather incoherent, kind of disorganized statutory appeals, often heard by a single person, not in a kind of proper tribunal setting, is that we miss the opportunity for, which I think a tribunal can do, even at first tier, and certainly if it goes up, to actually give recognise this is an important, perhaps the first case concerning packaging regulations, and actually it would be useful for everybody to make a fairly authoritative statement about that, which I don't believe that, I'm looking at Peter, he's not nodding his head, he's got that quizzical look, but I don't believe that the present statutory appeal system can do that. You'd have to wait and then to judicial review. So what I'm just saying on that, I think we are missing an opportunity for a kind of almost a declaratory, the opportunities of a declaration and the record, the public, I've just been trying, dear old planning inspector, I was trying to actually get that decision about the sewage, the consent decision, from their portal, their website. And it's just impossible. I can't get, somebody probably's got it here, but I went down and down and down, then they wanted the number, and I couldn't do it, and it just seems to me, hang on a minute, this is an incredibly important decision, and I can't find it on that, even though they've got, everyone's going to say, of course you should, if you knew, but anyway.
Chairman, could I just make a very, very brief comment on that? I mean, it seems to me that it may be the case that the extent to which you can justify setting up a court or a tribunal dealing with a particular subject may depend on the degree to which the particular system as a whole is or is not kind of fully developed and fully articulated. I mean, I think at a domestic level in the UK, where we confidently think that our system is pretty well developed. I mean, it has some deficiencies, and the cost issue is one of them. But we feel that it's a fairly well developed system, and therefore I think it's harder to justify establishing an entirely new court to fit into that. I think at the European level, I mean, there is obviously a developed system of European law, and there's the European Court of Justice, but I think that what is shining through the remarks that Carol is making is that there may be scope for a fresh look to be taken. If you were approaching this from an objective point of view, you would certainly say that you need to have a fresh look somehow at opportunities for redress in environmental cases at the European level, whether you need a new court or whether it just means changes to the way that the existing court approaches things, but there's certainly scope for change. And I would say at an international level, where the system is very imperfect indeed, less well developed even than the canon law system was, then the case for having a court, albeit only relating to one particular topic, I think is quite strong and could lead the way to better legal approaches internationally in other areas too.
Carol.
Just very briefly, yes. I mean, I feel a bit like a politician, actually. There's something that you wrote in 2004 might not apply in 2010, But, I mean, in 2004, we were very much looking at a system where we'd sort of evaluated the domestic system, and we'd found, a lot of criticism with things like costs and things like interim relief. And at that stage, we were so far away from ever sort of, I think, getting any changes to the cost rules that it seemed to be the best way to get some sort of bespoke system might be to have a separate environmental court. where you could have specialist judges and different cost rules and different rules on standing even, because at the moment the rule on standing is still actually relatively strict. It's just that we have a very liberal interpretation of it. Now that the sort of changes to the cost regime is in the offing, I mean, it's a massively sort of topical subject, I'm slightly more nervous about moving away into a separate court, and I can now see some of the strength of the arguments about actually trying to keep the law in mainstream issues, and so I'm a little bit more on the fence than I would have been before. But that's only because there are changes afoot, and if those changes don't happen...
There's someone over there, yes. Yes.
From Professor Corey, I liked your term unexpected alignment, and when one looks at how long we've been talking about an environmental court in the UK, I wondered if you wanted to comment on, or if you had any ideas what you think the timescale might be in any kind of implementation of this.
Well, I think the joy of going down the tribunal route and seeing what could we make of that, and okay, it's not the Big Bang court of the old style, but I think it could be incredibly important, is that under the new system, you don't need to pass primary legislation. I think, well, it's also very happy. I mean, I think actually, Sir Robert could almost just sign a piece of paper now, redoing the chambers, and it could be called an environmental tribunal, or we could combine the lands tribunal, call it land and environment, and then we have to work to give it some jurisdiction. Now, it's already got some jurisdiction under the environmental civil sanctions. I think then what we should be thinking about, as I've argued, is these various appeal routes, where I hope I've convinced, but I've convinced myself, maybe nobody else, that it's a pretty, haphazard system. Now, there will be a case, there'll be a political case. Some of these, as you see, the appeals go direct to the department, BIS, or whatever. Now, I don't know whether politically BIS would not want to give up packaging appeals, because they say, well, this is policy sensitive, we want to have the final control.
And can I just say something about this? Because
you're the one.
I mean, funny enough, Richard and I are sort of going back a long time on these issues, and the curious thing is we sort of diverge, because the report he was talking about on modernising environmental justice, which I wrote a foreword to, resulted in him being asked to write for the Cabinet Office about regulatory reform, and coincidentally I was asked to deal with tribunal reform.
And nothing to do with the environment. That's the unexpected alignment.
But in fact, we're sort of coming together again, because what you'll find with the tribunal system is, I mean, take for example the finance system. We now have a tax and finance chamber, which has brought together tax, duties, general and special commissioners, the financial markets tribunal, I think even the new MP's expenses tribunal jurisdiction. And so this idea that you've got a sort of pot in which you can put things, and the same in social security. And it seems to me that what has now started as this modest little FTT brackets environment jurisdiction, which I mentioned earlier, is exactly the right place for the people who are drafting the regulations in relation to all these things that Richard was talking about. Instead of just thinking, where on earth do we send the appeal, the obvious place will be there. And so, in fact, I think we can gather these things together, and without anyone noticing, in 5 years' time, we'll have an environmental tribunal.
Let me just do myself out of a job. I sit as a greenhouse gas officer.
Oh, right.
Oh, I'm sorry, yes.
Under deck.
Yes.
Yeah.
They appointed me as the appointed person.
Oh, right.
I think it's a sort of call-in type system. And as far as I can tell, I'm just allowed to get on with whatever I want to get on with, set procedures. It's completely open season, as far as I can tell. I haven't got any rules. And I think...
You've got plenty.
All people are worried about, all the department would be worried about, is if I said something that strayed across a nasty piece of policy.
Yeah.
Yes, I mean that's exactly what's happened. I mean, I
come and join the tribunal.
Come and join. No, we've got rules. We can give you rules. We can give you practices. But seriously, I mean, I think that's fine. But it's just not what I think Article 6 of the Human Rights Act is about. And but within a structure, we can be as flexible as you like. Sorry, jump behind now, yes.
Sam Blackridge, College of Law. I'm actually concerned with potential collision with environmental law and any other type of law. On a local scale, there's already quite big argument about people's right to enjoyment of land and for protection of it, and there's a contradiction there. But on an international scale, I think it's generally accepted now the planet's overpopulated, and if everybody wants, well, the same as I do, putting myself out on a limb here, just to alleviate poverty, there aren't enough resources on the planet. And the only way to do that is to bring the population down, which is infringing on a fundamental right to have a family. Yet these are the kinds of laws that will potentially conflict with any environmental court or law. I'm just wondering.
Well, I don't know whether Stephen has an answer to that one, I suspect.
Well, I mean, what I don't know if I have an answer to the, as it were, the substance of the point, but I just want to suggest that these are the kinds of issues in which courts could have a role to play. I mean, it seems to me that what we see around the world, and even in this country now, is we see judges being involved in policy issues. Of course, judges don't decide policy, but judges unquestionably analyse issues and analyse disputes in which policy plays a very central part, and I think that applies at all levels. It certainly applies, does it not, at the level of supreme courts around the world. We now have our own Supreme Court. I mean, if you look at the decisions which our Supreme Court has given since it was established, especially when it sits as a panel of 7 or 9, I mean, these are decisions in which policy plays a huge role, and in which the analysis of social policy becomes incredibly important. The Wolverhampton planning case just recently is a very, very good example, and what is, in my view, particularly fascinating about that case is that you get a sort of 4-3 decision, very much on policy lines. It's beginning to look incredibly like, it seems to me, the American Supreme Court. But not just at that level, I mean, at lower levels too, and if I may say so, in his presence, that Robert Calmouth's decision in the Heathrow case is another example of how, you know, the force of judicial reasoning can have an impact on the way in which policy evolves, without it being in itself a policy decision. Of course, the whole thing has now become totally academic as a result of the change of government. But I think that was a good example, if I may say so, of how a judicial pronouncement can have an impact on people's thinking and on the way in which a particular policy issue is going to evolve. So, you know, at an international level, I mean, the issue of population growth, which was mentioned in the question, seems to me that an international court for the environment could contribute greatly by the power of its reasoning to our understanding of the way in which population growth, for instance, impacts as a matter of policy on some of these other issues.
Yes, I think I'm hoping I'm not going to get that particular case in the near future. But I think just one more. Richard, do you have a question?
I've said this before, so stop me if I'm getting boring, but the whole issue of having an appeal tribunal was set up under the Patents Act 1949. We had the Patents Appeal Tribunal, and it was an extremely useful body. It could hear, it was very cheap, patent agents, as they were then called, and didn't pretend to be attorneys, could go there, and for next to no money. And it was very useful to the Patent Office, because it allowed the Patent Office examiners to go out on a limb sometimes when there was a new issue, and to say what they thought was probably right, rather than being cautious and just saying what was safe. They were able to do that, knowing perfectly well that the person involved could go to the Patents Appeal Tribunal and have it heard by a patents judge who knew what he was talking about and was able to deal with that issue properly. And that was very effective. And I certainly think that we need exactly the same sort of relationship with the Environment Agency. And they can have an internal appeal if they want, but that's simply an informal way of clearing out simple issues. But when you've got a serious issue, you should be able to go to an appeals tribunal, which is totally independent.
I think, can I just go, I mean, I think one thing very, very, on this particular issue, and I think, you know, I'm now getting re-inspired to kind of take this forward again, this one, in the best I can. I think it will be very important for those lawyers who represent industry who get caught up in these things to make the case that they would actually find an appeal, given that if there is a right of appeal, it's mainly going to be the applicants and so on at the moment, that to have that being heard by a body sitting within a tribunal is preferable to the present system, because one's going to have to persuade, there is politics involved in this, one's going to have to persuade the Ministry of Justice and BIS that this will not overall increase costs, it will produce more effective solutions and so on. And as I said, I come back again, I don't think the present system, and there's somebody like David, is broke. You're not an ignition event, giving a rubbish appeal. You'll be pretty good, I'm sure. And I'm just sort of arguing that you'd be even better if it was you sitting within a tribunal system with an upper appeal. But that's going to be it's not going to be easy to make that point. And I think one's going to have to argue in the current climate that actually, and it will improve for the Environment Agency, there will be appeals against them, and it will actually help them to feel it's a more consistent body. So we're going to have to get the regulators and the business, and possibly the NGOs, sort of all aligned if it will happen. But that's getting into the politics.
Yes. But I think probably at that point we've gone over time a little. Thank you all very much for being an attentive audience. Thank you to our three speakers for some absolutely fascinating insights into some very broad and important issue. And thank you to Herbert Smith for hosting this event, and particularly for Begonia Filguera, who has been the main organizer. And shall we thank our speakers with applause?